JIGL marathon. Now this is the series 3 of the JIGL marathon. I have already covered multiple chapters in my JIGL marathon 1 and 2. This I will be covering a few more chapters, and one of the most important chapters I will be covering in this marathon, and that too the very first chapter I will be covering that. Okay. Now I'll tell you which chapter I'm going to cover first in my marathon. That is your 3 criminal laws. Okay, that is comes for around 12 marks. So you have your BNS Act, which is one of the most important, with which I will be starting first. Now, before I start, I request you all to just share this video link among your friends, inform them as well, and let me know in the comment section if I'm audible and visible, so we can quickly start. Now, before I start, just a few more things. This chapter alone, exam, they are always asking around 10 to 12 marks in the examination. So I'll be covering all the exam questions that have been asked in this chapter and the entire module. So nothing else is going to be left out. Before I start, can I have GTG in the chat box that I'm audible, visible, so I can knock off the chapter for you? Great. Chalo, we'll start. Hi. So we start with a 12 marker chapter, which is your BNS Act 2023 among your 3 criminal. Now when we start the BNS Act, what it is. So the 3 criminal laws, what are they? Let's get the names right. Okay. So the very first thing is your law of crime. So when I was in law school, they had taught me that the law of crimes in India is the Indian Penal Code. So the Indian Penal Code lists down all the offences and the crimes that are there. Today this is called as your BNS Act, that's your Bharatiya Nyaya, that is Justice Sanhita, the code. Then the procedure to be followed in criminal matters is covered under your CRPC. CRPC is your code of criminal procedure, which has also been replaced, and now it is called as BNSS Act 2023. And then in the law of crimes, they had, to put someone in jail, they need to collect evidence. So we also had learnt Evidence Act, and that also has been repealed. And it is called as a BSA Act currently. That is your Bharatiya Sakshya. Sakshya means evidence, proof. So the 3 criminal laws, out of which the most important is going to be covered in this lecture. Now, let's start. With this, I will also be taking through certain summary notes while doing this chapter. So whenever you see the summary notes and you come to know that this topic, the keywords are there, the sections are there, the case laws are there, I would request you to write it in your book. Now let's start the chapter. Can anyone tell me under which section is crime defined, which I called as the BNS Act? BNS Act is actually the law of crimes in India. Okay. Under which section, you remember? Anyone knows? Answer is the word crime is not defined at all in the entire law of crimes. Instead, they don't call it as crime. What do they call it? Offense. Perfect. So that is what we need to know, that they have not used the word crime at all. See, the word crime is not mentioned only, does not provide the direct definition of crime. Instead, they say offense, that you have done an offense. They don't use the word crime. Crime is what we say it on a day-to-day basis. Legally, it is called as offense under section 2 subsection 24. So what is an offense? If I ask you all, what is an offense? Kid will come and ask you. Anything made punishable by the law, BNS Act, is a crime, is an offense. So anything made punishable by the BNS Act is the offense. Clear? So murder is made punishable, means it is an offense, yes or no? Yes. Now coming to the next thing, to understand the structure. Okay. Criminal laws are by default divided in two types. One is called as the substantive criminal laws and the other one is called as procedural criminal laws. Substantive criminal laws means what? What does substantive criminal law means? In substantive criminal law, whenever you open, you will see the definition of the crime given, the punishment of the crime given. So two things are always given: definition and the how much penalty will be given. So that was called as the Indian Penal Code, but today what we call it as BNS Act. So in BNS Act, what we will be studying: types of crimes defined and how much penalty it has. That's all. Procedure, how it is to be taken, is not given there. It is given in which act? The Criminal Code, that is your BNSS Act. Is the concept perfectly clear? The BNSS Act do not define any penalty. They tell the procedure to be followed. Is this concept perfectly clear? Yes. Let's move forward. So now we are going to see different kinds of crimes, their meaning, definition, what are the ingredients, and what is the penalty for that crime. Simple. Let's start. Okay. So just a little background. If when we start the Act, BNS Act, okay. So any act will start with which section number? One, obviously there's no section 0, right? Okay, so very simple. It'll start with section number 1. What does section number 1 always talk about in any act? Any act you pick up, section 1 will always talk about something. Very good. That name they call it as title or the name. And what? One more thing is there. Applicability. Excellent. So they talk about the application of the act. That where does the law apply? Whether it applies in India, in Jammu Kashmir, out of India, etc. Unlike other laws, this is a very rare law which also can be applied out of India. You know that? No. So if an Indian committed a crime in Canada, can he be arrested in India? Answer is yes. Because, so this is what we need to know, that in BNS Act, where all it applies, whether only in India or outside India also. So there are both. First, obviously the main rule will be that it applies intra-territorial. What is the word? Intra-territorial. So let's read it, that the BNS Act is applicable intra-territorial, means for all offenses, crimes committed within India, it is obviously applicable. But it can even be extended outside India under certain cases. Which are those cases also we will see. So that is called as extraterritorial jurisdiction. Territorial means out of India. Outside India also a person can be punished under this act. So let's read it in depth, that what is intraterritorial and what is extraterritorial jurisdiction. So intra-territorial means any offence done within the territory of India, BNS Act will apply. For example, let's take an example. Okay, so we are talking of one hardcore criminal. Okay, just like let's take a name. Okay, just a random name. We'll take Dawood Ibrahim. Okay, so we are talking about a criminal. Okay, now this criminal is Indian. So can that Indian be arrested if he does an offense? Obviously, yes. Let's say there is one foreigner, okay, who has come in India. Okay, let's talk about Brad Pitt. Okay, Brad Pitt, he came into India, and in India he went in the bar, he had a fight, and there was physical violence. He is a foreigner. But the crime of violence, assault, has taken place in India. Can the BNS Act apply? Yes, because offense is committed within India. So it doesn't matter whether it is Indian or foreigner or alien. Anyone committing a crime in India, BNS Act will apply. This is called as intra-territorial. Very, very simple. Now obviously it applies to Indians as well as foreign nationals. So all foreign nationals need to know the Indian law also when they are coming into India. They cannot say I did not know this. Now, this is so fairly simple. But what comes in the exam is extraterritorial jurisdiction, because that people don't know. When will the BNS Act apply out of India? So, extraterritorial jurisdiction means when the BNS Act can apply even outside India. Do you know? Do you all know? Let me know in the comment section quickly. Do you know? One perfect is there, that an Indian, wherever he goes and commits a crime, the act will follow him. So if he goes done a robbery abroad, he can be tried in India under the robbery, in the theft section. If he does, murder, he can be tried under the murder section. Very simple. So Indian committing offense anywhere in the world, if you have an Indian passport, BNS Act will follow wherever you go on the planet. This is one simple point. Any other point, Any other point? So remember the word ship. So there is a law in an international law is there, that whenever there is a ship, okay, and on that ship, it will be have a country's flag. Obviously, if Indian ship is there, it has to have the Indian flag. Canadian is there, it will have to. That's the rule. Now it is treated as a floating island of that country for which the flag is there. So India, and let's say a boat, a ship of India has gone in Australia, till it is a floating island. So any crime committed on that ship or with that ship, it can be tried in India. Concept clear? So that is called as dash jurisdiction. Obviously, I understood you are saying extraterritorial, but there is another key word for it. Anyone knows? Put in the chat section. Think, read your notes and tell me what it is called. A dedicated word has been used. Extraterritorial jurisdiction has three categories, right? We've done Indian committing anywhere. We are doing ship, and that ship part is called as admiralty jurisdiction. What it is called? Admiralty jurisdiction. That is any crime done on a ship or an aircraft. Even if a Indian plane is flying and there's hijack or there's hijacking or any kind of crime committed on the plane, but of India, the law BNS Act will follow. So any offense committed on any Indian registered ship or aircraft fall under India's jurisdiction. Okay, even if what, it is in international waters. Why? Because what word did I tell you? It is treated as a floating island belonging to the nation whose flag the ship or the aircraft has. So is the concept clear? This is called as admiralty jurisdiction. Okay, admiralty jurisdiction. So it is a part of extraterritorial jurisdiction, but here. Okay, so let me write. Concept clear till here. Then comes the third point. The third one is cyber crimes. Now, obviously, cyber crimes committed from any place outside India targeting Indian computer resources. So, if there is, you see so many hacking events happen. We see cyber warfare going on between China, India, China, USA, India, Pakistan, where they try to hack our computer systems and try to do that. So, all these cases we can still try a person who is outside India, because it is BNS Act will be extended abroad also, because you're targeting India. So again, extraterritorial jurisdiction first is covered under which section? 1 subsection 4 and 5. Extraterritorial jurisdiction is covered under section 1 subsection 4 and 5. What does it say? 3 cases: a person, a ship, and what is the third one? A computer. Concept clear? So you can just make a PCS. What is it? PCS as a keyword. Done. So any person, any computer, any ship, extraterritorial jurisdiction will follow, and the section is section 1 subsection 4 and 5. So sir, do we have to remember all the sections? Whichever sections I'm mentioning and explaining in depth, think it is important, it must have come in the exam. That is why sir is emphasizing, or it can come in the exam, that's why I'm emphasizing. Clear? Now, very simple case law, that a foreigner came into India and he broke the law and he said, I did not know in my country weed is allowed. In my, they have this marijuana is allowed, smoking drugs is allowed. You know, in other countries, what we call as drugs, it's openly had. So if someone from abroad comes in India and starts smoking weed on the airport, anywhere in public place, can he be arrested? Yes or no? Yes. So what happened is, this guy Mubarak Ali Ahmed, he came into India and he violated the law and he said, sorry, I did not know the Indian law. Is it a valid defense or not a valid defense? Not a valid defense. So you have to remember the case law also. You can quote it proactively if not directly asked. In Mubarak Ali Khan, Mubarak Ali Ahmed, that ignorance of Indian law is not a valid defense. Then one thing is there, that again, if anyone commits a crime in India, can he be tried? Yes, but there are two exceptions where the normal rule will not apply. Some people are exempt. Let's say exemption from intra-territorial jurisdiction. You will get a shock of your life that even if the president, governor, or a foreign diplomat or sovereign, like a foreign head of state, ambassador, diplomats, they enjoy legal immunity. So who all enjoy legal immunity? President, governor, foreign sovereign like a king, foreign sovereign or diplomat, head of state, etc. These people cannot be tried under the BNS Act. So, sir, what if a president commits domestic violence on his wife? What if the governor, okay, attempts to kill his political opponent and is caught in a conspiracy? Can he be tried under BNS Act? Yes or no? What I made you read, that these people are exempt. So sir, then what will happen to them? I'm asking you, what should happen to them now? They are all these, top position people. In USA also similar law is there. I'll give you a classic example. Bill Clinton. Bill Clinton was caught in, many women alleged that he had done wrong with them when he was under the president. So what happened, anyone knows? So as per the law, a president cannot be put in jail, governor cannot be put in jail, because it's a pura disrespect to the country. So the simple rule is, impeachment should first take place. They should be removed from their position. Then they are then they are no longer governors. This, and then they can be put in jail. So it doesn't disrespect the country. So that is the process that normally is followed. Okay. So who all would not ideally fall? They can also fall, but they have to first be removed from their position, then it is possible. Clear? Now we are talking of, so we finished BNS Act introduction and section 1. And section 1, subsection 4 and 5, intra and extra territorial jurisdiction. Till here, if you understood, hit the like button. Okay, so let's see. Now we are coming to the next part, stages of crime. Okay. Now, every crime has 4 stages: intention, preparation, attempting, and actual commission. Now, I want to know from you which stage is punishable under law and which is not. First 2 stages, are they punishable? First stage can never be punishable. If I have the intention, this guy is irritating me, yaar. During exam time, he's taking such slow lectures, feel like killing him. Okay, so then in that case, it's not a crime. But imagine if preparation, you bring a loaded gun, that if this guy doesn't complete the, this act within 1 hour, I will shoot him. Now you had intention and you came with a gun. Is it punishable, not punishable? So the answer is flat, not punishable. Okay, flat, not punishable. Only strict exceptions have been given. If in those exceptions, only then it is there, otherwise not. So we will see what comes under the exceptions. Otherwise, default rule is even preparation is not punishable. Like when can, like I'm asking you, logically, preparation, because you haven't tried doing the crime. You might have a change of heart. You might not want to do. You say, I bought it, but I don't want to kill him. So how do you prove? Only when it is there, when you're waging a war against country, then even preparation can be taken. Then if there is a separate preparation itself is given as an offense, it is mentioned that this is only an offense. For example, in law, if you know that even in possession of drugs is also crime. So having drugs is a aspect, but even possessing it is also a crime. So you must have had it, you must have just bought it to have, but still you will be under arrest because that is mentioned separately as a offense. Then a few more, any more you know, which other can be there? You think and tell me. This has been asked in the exam. Very good. So if you have seen that movie of Shahid Kapoor, Farzi, right? So what do? They fake notes, fake currency circulation you are trying to do. And any other points? Anything else? That's it. Okay. So these points are there. Only in these cases, preparation is also an offense. Simple. Then comes attempt. Obviously, there are some attempts which are made punishable only. For example, attempt to murder, attempt to suicide, okay, attempting to do an offense. So that also can be done. So these two, obviously, since you attempted, it could be, and actual commission will also be punished. Let's see. Now for this, I made short notes, so we can just refer those. See, first is criminal intention. Let's see, let's go through the points and then complete. Intention is needed. Now when I say intention, what in law from childhood we are reading, what is intention called? Mens rea, guilty mind. Okay, so let's read that. First is what we're reading, stages of a crime involves 4 stages we just saw. One is criminal intention. Law does not punish anyone for having criminal thoughts. Okay, now how do you but can I say mere intention is not a crime, but for a crime intention is required. So reverse is always true, that intention is not an offense, but every offense will have intention, right? For example, mens rea is needed. So if there is no intention, there is no crime. Okay. Now will a person say that I had intention? No. I'll say I just loaded a gun and I suddenly shot him. It was a mistake. So intention is inferred from a person's action, and sometimes reckless behavior can also be treated as intention. Okay, so legal perspective, that intention is always inferred from the person's action. So if I realize that I have, the person was running to and in with a knife towards the person, it shows his intention. His actions explain the intention. Preparation. I told you preparation is also not punishable unless the following cases are there. So mark it as important. Which are the following cases? So we did war, currency, coins, okay, and dacoity. Dacoity is also there. You did not say dacoity. Okay. So 4 points they have asked, that in cases preparation can also be treated as offense. So Which is it? War, dacoity, coins and currencies. Counterfeit coins and counterfeit currencies. Simple. Very, very simple. Let's write it down so that we will never forget. War, then comes currency, then coins and dacoity. Done. Then third we saw is attempt. Now attempt is again a preliminary stage from doing the offense. So just while actual commission, just before that you will have an attempt that you will do, taking direct steps. Types of attempt, offenses, let's see. So how do you define attempt? Which is not important, I'll just explain clearly. That attempt is under section 62. Okay. What do you mean by an attempt? Attempt is a direct movement towards commission of an act for which he was preparing. One. Punishable even if the offense is not completed. Maybe a failed attempt is also counted. Where not specifically covered, section 62 provides a rule, general rule. Like for example, there is a general rule that if X act has 2 years imprisonment and let's say you tried doing it but could not succeed. Attempt to robbery. Imagine a person came, tried to steal your purse and go. And let's say for theft, 2 years imprisonment is there. But someone attempted to rob you but could not rob. So will he be punished? But what will be the general penalty? Half. Very good. So it will always be half of the maximum punishment of the full offense. So mark it as important. Okay. So if no specific punishment is given, the punishment is half of the imprisonment prescribed for the full case. Suicide is also, attempt to suicide is also covered. Okay. Offenses where attempt and commission are separate. So even sometimes you have attempt as a separate section and actual commission of the offense as a separate section, then you will follow that particular rule. Only when it is silent on how much it will get, then we'll give half of the original, right? Okay. Now coming to the types of punishment. Now from here, I want all of you all to tell me all of this was there, only one is something new. Can anyone tell me what? From the types of punishment, one is brand new in the new act which was not there in the old act. Community service. Very good. And in the last exam in June 2025, they asked a question about community service only. So when is community service given, you know? Correct. For petty offences and examples have been given. So those from that he had asked in the exam. So let's see. Obviously, when you see types of punishment, slowly they are coming. The grade they are reducing it. Okay. So death, imprisonment for lifetime, or you can have imprisonment with rigorous hard labor or simple imprisonment where you don't have to work. Hard labor is not there. Of forfeiture of property, fine, and then last is community. Okay, now normally is death penalty given? No, it is in rarest of rare cases. The legal terminology that they use is rarest of rare cases. Okay, now and the president has a power to pardon. That's the last resort. If that also doesn't go through, then death is confirmed. Now it was established in Bachchan Singh versus State of Punjab. And we are going to see which all rarest of rare, in which cases you can have death, murder, dacoity, waging a war against the country, okay, abetting a suicide of a minor, attempted murder by a life convict, etc. Mob lynching is also covered and terrorism is also covered as per the new act. Clear? So few pointers you can remember, it is enough. Organized crimes can also come. Then rigorous or simple imprisonment, hard forfeiture of property, fine. Simple points, nothing to be explained. But which I told you is important. Community service. Okay. So what is community service. Let's see. Okay, so community service. Now what happened is, for minor offenses, so let's read how will we explain. Okay, for minor offenses, instead of giving traditional punitive offenses or punishments, the new act has prescribed community service. So we have to frame the answer also. So they have introduced community service for minor offenses. Then you will go on to say, instead of giving traditional punitive punishment, they have introduced community as a service. So the primary purpose of this is to get a balance between punishment and in rehabilitation of a person. Okay, so, and why this has been taken, purpose of bringing this is international best practice. It helps the person take a corrective step, it positively contributes to the society, and it reduces the prison system. So these few points we can write, that why community service was introduced. Now, very important, offenses eligible for community service. Now, obviously, it will only be for minor offenses where the following of them have been given. So let's say public. Yeah. So some of them I have summarized also. Okay. From exam point of view, that the court may give community service if unlawful engagement of public servant in trade. So public servant tries to do business, or a person has not appeared before the court after being proclaimed to come to court. A person has attempted to commit suicide, or to influence a public servant, attempt to commit suicide to influence a public servant. What does this mean? I go and tell that a public servant, police officer, if you don't register my case, I will kill myself. So it is, what am I doing? I'm attempting to commit suicide to influence a public officer that you better do this, otherwise I'll kill. Because sometimes they do like that in villages where they don't listen, they'll say, I'll jump from here if you don't do this. So what are you trying to do? You're attempting to commit suicide with the objective of influencing a public servant. Okay, petty theft of less than 5,000 rupees for the first conviction if property is restored. So if you've done a theft of up to 5,000 rupees and it is your first time ever and you've given the goods, then in that case community service can be given. Public misconduct by a drunken person and defamation. So in all these cases, community service can be given. Okay, and one important thing, that a community service is mandatory in petty theft. Okay, so community service has become mandatory in petty theft where the value is less than 5,000 rupees. Now, coming to an important part of difference between fine and penalty. No, sections of that is not to be learned. It's not come, but it's not possible to learn also. Okay, to learn for the community service, you can't learn the section, but at least the key headings is enough. Now, my question is, what is difference between fine and penalty? What is difference between fine and penalty? Okay, so I'll tell you. One is civil. I'll give you a hint. One is a civil case. In civil matters it is used, and the other one in criminal matters. So before I get into that, let me tell you, normally in all laws it is interchangeably used. They are just using fine and penalty always without, plea. But we are students of law, we have to go into the real depth and know what is right, what is wrong, when someone is misusing that terminology, not knowingly also. So let's understand the word correctly, and then I will give you a hint where you will never forget it. One I'm telling you is a civil used in criminal matters, and one is used in civil matters. Can you tell me which is used in criminal matters? Fine. Very good. So this is used in criminal cases, and penalty is used in civil cases. Sir, can you prove? I'll give you one proof that you will understand. Whenever they say imprisonment or dash or both, what is it? Or fine. They always say imprisonment, that is jail, or fine or both. Have you ever in your entire any law read that imprisonment or penalty or both? No. So fine is always used linked with imprisonment. So they show that it is a criminal origin. And otherwise, in company law, if you delayed in filing the form, you don't get penalty. What do you get? 200 rupees penalty is to be given. In RTI also, penalty word is used. That if so, very simple. Let's get into this. The direct differentiation. Okay, so you can see the difference and then build up your answer. Let's see. So fine and penalty. So fine is always imprisonment or fine. So it's an offense. Criminal law, normally it is, or used along with imprisonment, and examples are Companies Act. When they write imprisonment, they will mention fine. Your law of crime, SEBI Act, whenever they put fine, imprisonment, they use the word fine also. Whereas when I go for penalty aspect, you will see in the similar acts when imprisonment is not there and they just want to levy some delay monetary penalty, so they call it as monetary penalty, right? Penalty. So consequence for non-compliance. Okay. It could be used in civil matters. No imprisonment, only monetary liability is there, and non-compliance is the GST, Companies Act, SEBI. In the same acts also they use the word penalty. Right. Now we are coming to elements of crime. What are we coming to? Elements of crime. Okay. Now we are coming to an important aspect called as elements of crime. Now, for a crime, one has to be a human being. Animal, killing another animal is obviously a murder, but not tried under civil law, because only human beings are able to make rational judgments. Animals have animal instinct, that is why they can never be covered. Second, minor is also a human, but age limit is there, so therefore they also cannot be held liable. Third, if someone is drunken or they are intoxicated, then in that scenario also they do not have intention, so they can have exception, which we will see. Then act, obviously there has to be some positive steps taken, actions then, and mens rea is intention. So if we just go back, just see the summary aspect of it. Okay. Now, first we're talking about human beings. That the first requirement is that the act must be committed by a human being. Simple. There must be a legal obligation that physically and mentally fit for conviction. Only human beings under legal obligation are capable of being punished. So when I say that he should be physically and mentally fit, means should not be a drunkard or should not be a minor. Then comes guilty mind. Okay. Now guilty mind means what? The principle of criminal liability, that actis non facet mens rea. When you see the word mens rea only, means what? The act alone cannot amount to guilt unless accompanied by a guilty mind. Means that the act itself is not wrong, not crime, unless it is accompanied by a intention. Now intention is a mental element, attitude, okay, and is identified or judged from the external conduct of a person. Now we are seeing types of mens rea. Okay. So first is intention, purpose with which the act is done. Negligence means a person they have a word, okay, gross negligence. What word they use? Gross negligence. What does it mean? That it was your duty to take care. Any person in that place would have taken care, and you did not take that care. Okay, so you failed to take reasonable care when it was your duty to care. For example, a doctor came and gave a wrong injection, or so then what was it, that he did not have intention, he said I don't have mens rea. But we say, listen, basic negligence is not covered. Basic negligence is not covered under your mens rea aspect. Gross negligence is covered, means that it does negligence for such a big level that we will attribute the intention. Similarly with recklessness, okay, you're taking such high amount of risk consciously that it totally disregards the consequences. For example, I take a sword and I throw it outside, or I take a TV and I throw outside the window. So now it is recklessness. Recklessness where I'm taking a conscious decision. I don't intend to kill anyone, but I know that throwing like this, even if you could see, drunken driving is covered as a crime. Why? Because when you know that you're drinking and driving, you are taking such high amount of risk and completely disregarding the consequences. Clear? So you can write INR when it comes to mens rea. And one case law also you can write, that is Girjanath versus State. Mens rea is a broad term of various mental states, okay, and it can be implied through the words and actions. Okay, mens rea, even though the mens rea is not used now, there is no section definition of mens rea. Okay, but the words BNS Act uses to show mens rea, guilty mind, fraudulently, intentionally, dishonestly. So what all they are trying to show? Intention. By default, mens rea is not mentioned in the entire BNS Act. But you can make out that the intention is word by using the word intention, voluntarily, fraudulently, dishonestly. So these are implied through the words. Concept clear? Now, mens rea further. Exceptions to mens rea. Again, very, very important. Exceptions to mens rea. Certain offences do not require proof of mens rea, okay, and you can still be held under criminal law. So mens rea normally is required, but when mens rea is not required, and still you can be tried under criminal cases. So let's see, have you understood what we are trying to do now? You understood or no? See, again, let's see that exceptions to mens rea. While mens rea is an essential element in most crimes, there are exceptions where mens rea, a person can be held without guilty mind. So, when and how it is possible? First is statutory law. If in company law they have said if this is not being done, directors can have imprisonment. Now there might be so many directors who don't have intention. Okay, statutory law imposes liability in presence or absence of guilty mind is irrelevant. If the law directly says imprisonment, so it will be there. Examples of, if imagine a director is there which is of medicines, okay, motor vehicles, etc. In all these cases, it is covered. When it is difficult to prove mens rea, so in small cases, it's very difficult to prove mens rea. In public interest is involved, okay, where oleum gas leak, many people died, very difficult, and offenses without knowledge. So even a foreigner coming into India committing a crime, he never had the intention. But ignorance of law is never allowed. So if we come back and we see when all it is a public health, the law has been stated, difficulty to prove and ignorance of law. How many points? 4. Which are the 4 points that mens rea is not required? Well, public health is involved. In law, negligence Public health, welfare, regulatory offense, difficulty to prove, and ignorance of law. So ignorance of law, I did not know the law, so how an intention will come? Still you're covered. When mens rea is very difficult to prove in minor offenses. For example, your helmet you did not wear. Now I did not have the intention, I forgot, I thought I am wearing a helmet. Or I jumped the signal, I did not see the signal. Still. Okay. A regulatory offense, traffic, etc. Or even in company law. Now, corporate body and mens rea, again very simple. In case of a company, mens rea is always attributed to whom? For example, company also is a person who can be held guilty, but they cannot be put in jail. So, a company can also have criminal liability, but it itself doesn't have like a human mind. So obviously they use the word persons to include companies, association, bodies of person, and whenever they say mens rea, they always senior officials will be held liable. So there was a case where safety measures were not given to the laborers. It was held that the directors will be held liable. Clear? So where a body corporate is liable, it depends on the nature of the offense, position of the officer who had the knowledge, etc. Okay, state of Maharashtra versus syndicate transport. So persons include everyone, and even companies can be criminally liable, but the mindset will be of the directors, deemed directors, and they can be held liable. State of Maharashtra versus syndicate transport, that liability of a company depends on the nature of the offense, position of the officer, etc. Held that criminal liability is possible where a statute and facts justify it. Clear? Now we come to the most important part of the chapter. Okay, what is it? All the offenses. Clear? Till now, have you all understood, yes or no? Because till now they were only introductory parts about your BNS Act. What was BNS Act? Then what it had section 1, intra and extra. What else we saw? Then what else we saw in this? Yeah, the punishments. Which type of punishments are given in BNS Act? Stages of crime: preparation, intention, types of punishment, and fine, penalty, that much. Okay. Now we come to the most important thing. Now before we start this, I will give you a beautiful summary in the very beginning. So you never even have to, when I'm doing it, you will know it perfectly. Is it clear till here, yes or no? Till here it is clear, yes or no? Great. Okay. So now let's start. So the very first one, pay attention. Okay. That theft. So remember the section number, which it is 303. Now what is theft, you tell me? So I'm just remember, theft, what happens? Someone comes, snatches, takes something out of your possession and runs away. So first of all, is intention there? Yes. Okay. Then they take any movable property. Always theft is for movable property. Okay. And you have been taken out of your possession without consent. It is said to commit theft. Simple. Snatching is a type of subset of theft. Snatching is basically quick grabbing of a movable property of a person. You forcibly seize, so snatching is a type of theft where you take a person's movable property out of their possession. So what is the key word? That intention, and I could also say movable property is an important word, movable property, and without consent. You take someone's movable property without their consent, it amounts to theft. And in snatching, what it is, you forcibly snatch, grabs. Snatching word is only there, so I'll say grabs movable property, right? Then we come to the next one, which is called as extortion. We come to the next one, that is called as extortion. What we're doing? Extortion. Now, what is extortion according to you? We've seen, obviously, you can visualize a movie where they call that, your daughter is with me, or if you don't give me so much money, we will kill your daughter or son or child. Now, this, if you don't give me so much money, we will do this crime. So, in this, again, they use the word intention. One, you put the other person in fear, okay, and then fear of injury, etc., and then tell them, induce that person to deliver any property to you. So, what is the ingredients? That obviously intention will be there. You put a fear, and after the fear, you tell them to deliver the property. Deliver. So, this is called as extortion. Concept clear? Very simple. So, you can write the section numbers also, you will be sorted. Then comes your robbery. Sir, what do you mean by robbery? Now, in robbery, we did two offenses before. Which two? One we did theft, and the other one we did extortion. Now, robbery is a extreme case of theft or extortion. Now, pay attention to what I'm saying. So, when theft is there, let's say if someone is stealing something, with that, if they add fear of injury or threat, it becomes robbery. Concept clear? Means theft plus fear of injury. See what they'll give, that in theft or extortion. So when theft or extortion becomes robbery, so first of all, theft and extortion is here. If something more is added, it becomes robbery. If something more is added to theft, it can become robbery, or if something more is added to extortion, it can also become robbery. So what is that thing? That the offender voluntarily causes or attempts to cause hurt, death, or restraint. Tell me one thing, in both these definitions, theft or extortion, was there a case where they had mentioned that death will be caused, restraint will be caused? No. They had told that yes, we will be doing those two things, taking out of your possession, etc., and to deliver, but word death, hurt, or restraint is not mentioned. Clear? So if we put fear of injury or fear of hurt, injury, or I could say even death, then it becomes robbery. Concept clear? Next, if I take extortion also, in extortion I call and I say that if you don't give me so much, I will kill you. Or you've seen movies where they say that 50 lakh rupees give me for protection money, otherwise I will kill you. So that is pure extortion. But if with that extortion, I will kill, the moment they use the word I will kill, plus death threat is there. Death threat is there, or in extortion you even add or restraint is there. For example, I take someone in custody and I say that this person is sitting here, I'll not let them go till I get so much money. So then it becomes extortion plus death threat or restraint becomes robbery. Concept clear? Simple. So a simple case of extortion could be give me money, others I will hurt you, or give me money, within so much time, otherwise you will see what will happen. So that is a plain extortion. But moment I add the word I will hurt you, kill you, I in robbery also you go to see extortion plus robbery could be where there is total restraint, means the person is very close to you, that he's restraining you. So there seems like there is like in your surrounding only where he's blocking you, tying you up, etc. Clear? So I could say in simpler words, robbery is a extra version, more a severe version of theft or extortion. Okay. Then comes dacoity. Now all these crimes was all done alone. In dacoity, you 5 or more people come together to commit a robbery. Concept clear? In dacoity, 5 or more person jointly commit or attempt to commit a robbery. And what is the interesting thing that was there, that while committing dacoity, there are 5 people, and one went and killed the person, a villager. So there was an example that there were dacoits, 5 or more persons, gang war. So a group of people came, they tried to commit robbery. Okay, so all it's very high all the way. So can I say robbery is here? First, theft and extortion is here. On top of that is robbery, and on top of that is dacoity. Because in dacoity, robbery is happening with 5 or more people. So 5 or more people they came, they entered into a village, were looting someone. While going, one of the dacoit, one of the robbers, killed someone. So it is held that everyone will be held for murder also. Okay, that was a case law. That dacoits, the entire penalty will be given to all. Then comes criminal misappropriation of property. Very, very simple. Now, all these all go hand in hand. Okay, all this has to be studied hand in hand. All this will be studied hand in hand. Okay, theft, extortion, robbery, dacoity. Now we go into another category altogether, which is criminal misappropriation of property, criminal breach of trust, and others. Now we are seeing the other category, which is criminal misappropriation of property. Now understand this. What is happening is misappropriation of property means I am making someone else's goods my goods. Someone else's goods I'm misappropriating for my use. Okay, so first of all, there is a dishonest intention, that is why it is criminal. One, misappropriates or converts to my own use any movable property. So it has to be first dishonestly, though it will always be there. You convert to own use movable property. So these are two things that I want you to write. So let's take a classic example for this. And let's compare it with theft. Let's compare it with theft and understand the difference. So we saw theft and we saw criminal misappropriation of property. Clear? Now, in theft, what is happening? I remove a person from possession of movable property. Okay, so you remove person from possession of movable property. Clear? In criminal misappropriation, I'm not removing any person. I'm just converting someone's property to own use. And that too, it is someone's convert movable property to own use. Sir, what does that mean? Can you explain? So here, if I find a mobile phone, you found example of this, classic example is find a phone. The moment you find the phone, did I dispossess someone? I found a phone. So my introduction to the property or I acquired the property legally. I found the phone. Okay, there's no dishonest intention there. But then I realized that it's a phone or it's a watch or it is a ring and I keep it for myself. Then it is misappropriation of property because you converted someone's movable property for your own use. In theft, you remove someone intentionally. So if I remove someone's from the phone from the pocket, then it is theft. Minor slight differences there, nothing else. Here you remove someone proactively, so your possession of the property itself is wrong. Here your possession of your property is innocent. Concept clear? Misappropriation of property. Simple point. Now come to criminal breach of trust. Now we come to criminal breach of trust. Sir, what does criminal breach of trust mean? A clear word that you can see here, which is most important, is what? From this, which is the most clear word that you can see? Entrusted with property. The main keyword is very close. It is trust. So I always make this type of thing here. This is someone's heart. What did you do? Broke the heart. Okay. So this is someone trusted you and you broke the trust. So the very first element will be of trust. And then secondly, that guy, what did he do? Misappropriated, broke the trust. So two big elements are there to understand, and no other keyword is important. Okay, one is that someone entrusted you with the property, okay, and then you misappropriated or converted for your own use. So it violates trust. For example, I had an agent, I gave that agent my goods because I trusted that he will sell it and give me the money to me. What did he do? He took the goods and he ran away. So he broke my trust. When I created a trust property, Ratan Tata, when he made Tata Trust, he keeps trustees and employees there to work for the benefit of people. When these people don't work for the benefit of others, so first Ratan Tata trusts his employees. When an employee does robbery or when an employee converts that money for his own use, it is called as criminal breach of trust. A warehouse keeper was, I had kept some chocolates and I had given the warehouse keeper that you keep it here, I'll come on my birthday and I will take it. What that warehouse keeper did, he opened it and I saw that there are 5 less and he had 5 children. Okay, so accordingly I come to know that he broke my trust. So breaking of trust is criminal breach of trust. Receiving stolen property. So again, for example, a thief goes and gives a stolen property to someone and someone assists, abets, encourages, okay, receives the stolen property, can also be punished under the act. Simple. Cheating. Now what is cheating? Till here, is everything crystal clear, all the offenses? Yes or no? I'm covering every single offense. Nothing out of it can come. All the offenses clearly I'm explaining to you. Now coming to cheating. Whoever deceives. Now pay attention to cheating, how it will come. Now we are taking cheating, okay? So whoever deceives a person or fraudulent, dishonest to deliver him any property or intentionally causes harm by deception is called as cheating. So in cheating, there is 2 things. One is a deception. So someone is being very, very smart. He is fooling you. So can I say deception means fooling? Means to, he is fooling you. He is not using force. He is not taking and running away. He is doing like what scamsters do. What scams people do. In scam, what they will tell you, especially you see those scams like where your parent or your mom must have fallen for it, that you make 2 members, then they will make 2 members, then they will make 2 members. In reality, nothing happens. So, but they make it very interesting. Nowadays on social media, you will see, we will make this, we will do this. What are they doing? They are deceiving. It's a scam. Scam will come under cheating. Why? Because you got fooled, and you yourself, after being fooled, you were induced to deliver any property, any money, anything to them. For example, if one comes and says that you give me the money, I will ensure that you get a job in Dubai. Or if I say that you give me money and I will introduce you to Shah Rukh Khan. Who's your favorite actor? Nobody. No actor. Who's your favorite actress? You all tell me. Nobody. Acha. Okay. So let's say if you have, let's say you're a fan of someone. You're a fan of anyone. Harvey Specter, yes, correct. So let's say Harvey Specter from the Suits. Now, when he's there, you'd like to meet him. Now, someone comes and tells you that Harvey Specter is coming to India, and to meet him, you have to pay 10,000 rupees. Now, you pay 10,000 rupees, and then in the end, you don't get to meet him. So, it's a scam. So, you have been deceived to pay some money. Okay. So, cheating is very clear. You cheat someone. I'll give you another simple example: is a fake diamond. What do you do? And you help them to deliver the property. So let's say there is a fake diamonds. Now with a fake diamond, I sell the product and I ask you to deliver your money to me. So cheating. Now comes forgery. Forgery is always with respect to documentation, records, which causes damage to someone's reputation or gives you unlawful gain. So forgery is making a false document or electronic record either to cause injury or to get benefit. And defamation is very simple. You make any statements, signs, words, representation with the intention to cause harm to someone's reputation. Defamation could be of two kinds. Which are those two kinds? Libel and slander. Slander is you defame someone by words, and libel is basically through any permanent form like a cartoon or something like that. Okay, so let's go through quickly all these points and complete it. So what was theft? Section 303, dishonest movable property out of someone's possession without consent. It's movable property. Then comes snatching, is a part. Then when you go to see extortion, that there will be a fear of injury, and then they induce the person to pay any valuable security. So the person themselves give. Now there was a classic case law which I would like to take you through, and whether you have to tell me. It is a case law relating to extortion. Okay. Now a person came. He on gunpoint he told that put your signature here. Is that extortion? Answer is no. Sir, how come? Because when someone is forcing you to do, that is not very, and takes your hand and puts the sign, that is not covered. In extortion, due to the threat, you yourself act and give. So here a forcible thumb impression means I am not doing. Whereas in the definition of extortion, that due to the threat, the person does by himself. That's the difference. No extortion because there is no voluntary delivery. Okay. It would come under criminal force or assault. So consent is taken in extortion always through force. Robbery we did, dacoity we did, criminal misappropriation. Now, in criminal misappropriation, I give you an example that innocent possession was acquired, but I retained it dishonestly. Will it be treated as misappropriation? Answer is yes. Now, there was a case law in Muhammad Ali versus State. The person had possession of goods but did not have purchase receipts. Can it be treated that he is wrong? Misappropriation. Just because you didn't have the bills doesn't mean that you have misappropriated the property. Answer is no. Misappropriation of property, intentionally keeping someone else's goods, that is there. Okay. Now another case in Udhar Dhar versus state of Jharkhand, a civil dispute was there. A civil dispute between a contractor and subcontractor should go in Consumer Protection Act or it should go in some Civil Contract Act. It will not come under crime. Okay. Misappropriation of deceased person. So there was a person in a road accident who died. Someone came and took his mobile phone. So it is misappropriation of property. But of a deceased person, a little more higher penalty is given. Clear? Breach of trust is entrusted with property over a domain, misappropriate, converted to its own use. Okay. And a classic example of this is I trusted my employer with my pension funds. I gave my pension funds and he misappropriated for his own use. We'll come there. So in this, in Dalal versus Yugendra Naranji, what did they say? That entrustment, first trust will be there. Without entrustment, there is no criminal breach of trust. Okay. Similarly, in Pratibha Rani versus Suraj Kumar, Shridan, she gave it to her in-laws and the in-laws were not returning it. So again, it's a misappropriation of property because they took it legally, but later retained it, so it became illegal. Clear? So again, in this mathematically impossible money schemes, Ponzi scheme can amount to cheating. Now coming to fraud related to property. We're coming to fraud related to property. Okay. Now, criminal misappropriation of property. Let's see. Now, in criminal misappropriation of property, one is to transfer certain property with the intention to defeat creditors, one, for less consideration. Then, fraudulent deeds with false statements. This would come under Benami. That's it. So let's complete these parts. Okay. Now very simple. If there is a home loan on your property, and nowadays this crime is really not possible because the banks and the creditors always keep the title papers, so you can't sell, right? So normally this misappropriation of criminal misappropriation of property means what? You convert another's movable property for your coming to. We've done all this criminal breach of trust. All of this completed. Cheating we've done. Now offenses related to. Okay, we'll just start this. 1 second. Now we'll see offenses against property. Simple. Now the very first one is fraudulent disposition of property. Let me explain very simple. If today there is a home loan on your property, okay, and always this is related to immovable property. Which property? It is related to which property? Immovable property. Okay, so we'll come when they come. That if I come to know that the creditors will come and take away the property because I could not pay it, so what would I try to do it? Try to sell it way before. at a less consideration. So what are the ingredients of this? That fraudulent documents that I make to dispossess the property, to transfer the property. Okay, dishonestly, fraudulently removes, cancels, transfers the property with the intention to prevent the lawful distribution among creditors. It is punishable. Then they tell you for how many years it is punishable. Okay, so in Ramathur versus Hari Ram Todi, they have said that what is the essential ingredients of this. Very simple. First of all, accused must have removed, concealed, delivered, or transferred the property without adequate consideration, with the intention to deceive the creditors so that the creditors don't get any amount, and he has acted fraudulently. Okay, so the offense, and they've given you the how much penalty it will be there. So again, if we go to learn what is it, that there are, what all points are there in this. First, property is transferred, okay, without adequate consideration, dishonestly. And what is the purpose? To ensure that the creditors receive nothing. So when a property is transferred without consideration, to defeat or delay the claims of creditors, it is called as your fraudulent deeds and disposition of property. Clear? Now, coming to the next one, similar point is if any deeds with respect to property, okay, if any deeds with respect to property contains false statements, okay, with respect to consideration, or to for whose benefit it is made. So very simple. This comes under Benami transaction. This comes under what? Benami transaction. Sir, what do you mean by Benami transaction? Now you must have seen so many politicians, they have property in their name. Now see, if you go to see, even the president of India has a salary of less than 5 lakh rupees. Now because of, even when the president of India is having such low salary, how can someone have so many crores of property? And they don't have it in their own name, they have the property in another's name, and then they give, the consideration is given by them. So they will have a document that this, the son is paying me the money, when in reality it is a, so when dishonestly, whoever dishonestly signs or becomes a party to any deed or instrument where the property is being transferred and which contains a false claim with respect to consideration, how much money is there, or to for whose benefit it is there, okay, then he will be punished with so much amount. Okay, so there is a false statement with respect to consideration or for whose benefit it is there, it is related to Benami transaction. Okay, now we go to the next one, which is called as forgery. Sir, what do you mean by forgery? Forgery is basically when whoever makes any false document, electronic record or part thereof with the intention to cause damage or get any benefit, okay, commits forgery. If a person did not have fraudulent intention, can it be forgery? For no. So for forgery, dishonesty and intention is very, very important. Now a document was altered, but it was no proof that it was with intention to deceive. Can it be called as forgery? No. Now there was a very classic example which they ask in the exam also. Belbir Kaur versus State of Punjab. Now she was a teacher. She produced a document that I was teaching in this school, and falsely she stated that it was a recognized school and she worked for that many years. She thought it was true. So it was held that it was not a false claim because she was actually working there. So it was not a false claim on basis of the fact that she did not intention to deceive anyone. Then we comes offences related to property marks. We're going to see offences related to property marks. Now all these products, you have eaten these products, yes or no? Answer is no. All these products are counterfeit. They just look same. You see Puma, Coca-Cola. Okay. Then you have this Coolgate. Then Bristol, Kicker. Okay. And then Ponds also what it is? Pounds. P-O-N-O-S. It's so close that one cannot identify the difference. P-O-N-O-S. It looks like Ponds. What? O-N-D. Yes. So due to that similarity in alphabets, they take the advantage of that. Okay. So now what is it? These are called as in intellectual property rights. Also, we have trademarks being violated, infringement, in criminal law. Also, it will be, it will be punishable. So, definition of a property mark: a property mark is like a trademark, which is used to denote the movable property that it belongs to this business person. So, a mark used to distinguish a business from others is called as a trademark. When someone uses deceptively similar to cause confusion in the minds of the people, it is called as, it is a punishable offense. Okay. So whoever makes any movable property, mark, logo, etc., that misleads the public that it belongs to someone else and uses such misleading marks, it is said to be using false property marks, and for that you have punishment up to 1 year, that is there. Then comes defamation. Defamation law is also very simple. Any false statement with the intention to reduce a person's reputation is called as defamation. Okay. So defamation could be of two kinds. Okay, libel and slander, which we've seen, but one very important: what are exceptions to defamation? What are exceptions? This is important. Meaning, I think everybody would be knowing that we've done what is defamation, libel, slander is very simple. We've done that before also. Okay, now we are seeing the exceptions to defamation. When a statement is not defamation. If I give a honest opinion about a movie, about a book, or if a food blogger gives that he found that a restaurant is extremely unhygienic and having horrible food, or if a judge proclaims you as a criminal, or if a public servant has arrested you and taken you to jail, thinking that taken you into custody, thinking that you've done something wrong. Now, all these things cannot come under defamation because the person acted in good faith. The very first ingredient is dishonestly makes a false statement. So, wherever someone does a public good, for example, if I say don't go here, he's a fraud. Or opinions on public servant, if I say that this person I feel is not having a good character, I genuinely believe it. Okay. Reports of court proceedings, witnesses. Now, witness will say that I feel that he has done the crime, so it cannot be said to be defamation. Public performance criticism. So, if someone is performed having a artist, you can criticize them. For I think there is a lot of ongoing memes for this actor. Who is he? Every time they come, you don't watch. Okay, I think Arjun Kapoor. No, okay. So a lot of memes that go around these actors, etc. That is there. Okay, so they cannot say because this is just a public person who I'm talking about. Politician so many times. Okay, your censor board is there. Complaints to authority. So if I make a complaint to an authority, obviously it may turn that he is not guilty, but that doesn't mean that I am defaming him. Okay. So all this is simple points acting in good faith. Libel, slander, very very important. Libel means what? See, always remember slang language. Slang is always in spoken words. Does not have any concrete permanent form. Okay, speech, broadcast, words. But if someone has any in a non-transient form, transient means temporary. In a non-transient means a permanent form, then it is libel. Cartoons, books, writings, images, movies, blogs, etc. would come here. Then comes to the last part. Okay, last part where you just understand the basic logic, your entire concept will be completed. Okay, now this will be taken by all the criminal lawyers. So if you are planning to become a criminal lawyer, okay, this becomes your most important thing, because these are defenses. What are these defenses? If tomorrow you are brought in court, you can protect yourself by choosing one of the legal defenses. For example, self defense. Another example is exceptions to defamation. I did it in good faith. Second is act of judge. If a judge, you know, put you in jail and later in appeal it was released, the person was released. So he acted in good faith in statutory powers. So again, I cannot be held liable. Okay. Mistake of fact. For example, I went and I thought that a police officer, let's say a police officer, went and he thought that the robber is behind that door and he shoots and unfortunately hits someone else, or in order to catch a terrorist, bullets were exchanged and an innocent civilian died. Now it could be in good faith, or it could be a mistake that I thought you were a terrorist and that is why you killed. Court orders, okay, anything even under the court order is not there because judicial duty. Mistaken belief, accidental acts, okay, with the accident that happened, like even a doctor is sometimes not held liable if it was not his fault and it was an accident, but it could happen with anyone. That is why they make you sign that anything happens you will not be held liable, because we are doing a very things which can have misfortune. Prevent a greater harm. Okay, let's say a small baby is there and you threw him from the first floor. Can you be held liable? No, because if the building was in fire and he would have died, so it's better, you thought that to prevent a greater harm, the firefighter through the child, he can take this as a defense. No consent of the baby is there, that is different. Okay, now another defense, you can say a act of a child under 7. So even a child under 7 kills someone, he cannot ever be criminally liable. So next time if you want to do a crime, from whom you should make it do? A child who is under 7. Very good. Okay. Acts of child from 7 to 12. Now below 7 nothing happens. If someone is between 7 to 12, then if he has attained sufficient maturity, then he can be held liable, and that too they do not give them jail, they give them rehabilitation is given. Person of unsound mind, a person drunk, a person having schizophrenia or unsound mind, so they also cannot be held liable. Intoxicated person. Okay, act done with the consent. Okay, for example, in these sometimes we see in boxing matches someone dies, or we could say in cricket one person died after the ball was hit on the head. Okay, so all these things, the consent was given that he was ready to play this game, this sport. Combat sports are there, so but he didn't give consent to die. But in the process, bungee jumping, we just saw recently, we just checked that the bungee jumping rope only was broken. Doctors, very good, comes here. Okay, then act done with consent for a person's benefit. Okay, a doctor performs a risky surgery. So all these are exceptions that you can say. These are all defenses, private defenses, cannot be held. Okay. So with this we have completed the entire chapter of BNS. Thank you. So the sections which need to be learned, I've explained from the table. No, no, exceptions itself is not that important. It hasn't come that many times. Just the basic headings is enough. Exceptions you don't need to know. Clear till here? Yes or no? Right? Clear in the chat box if it is clear. Let me know in the chat box if it is clear. Yes or no? Great. Okay. Now, today this was an important chapter. Okay, that is important. And next we will do, not today, the BNSS Act. I'll do it later. Today we'll do another act. Simple. One heavy, I can take Law of Torts, get over quickly, and Information Technology Act. Which one you want to do first? Law of Torts में फटाफट complete हो जाएगा. So we'll complete the Law of Torts. Clear? Kalpana, great. What about others? Let me know. So I've completed the entire chapter, including all the past exam questions, even of June 2025. Okay, so from there only it will come. Great. Now I'll be covering another topic, which is your Law of Torts. Okay, you'll get over really fast. So from exam point of view, you're sorted. Okay, we'll just take a 2-minute break and then we'll come back. Just 2 minutes, we resume. Great. So am I audible and visible? Let me know in the chat box so we can quickly start and complete this chapter. Great. So what we will be doing is this chapter, I will be completing it. I will be telling you what are the important things. All you need to do is note it down, okay? With me. Great. So let's begin. Yep. Great. So let's start. Hi. So we'll be starting with a chapter called as Law of Torts. Now this law of torts you must have already done in the first level also, and in this level I will be telling you what comes from exam point of view and all the key important terms as well. Now law of tort is, if you go to see, this word tort is not English origin from what we know. The word tort is a French word which means wrong. Okay, it is derived from the Latin word tortum. Okay, and in simple words, if I have to explain what does it mean, a tort is a civil wrong. What kind of a wrong it is? Civil wrong. Okay, now when I say civil wrong, means criminal wrongs are called as crimes, and for that you have your BNS Act and 3 criminal laws. Whenever you have the civil wrongs, it is called as law of tort. This is a uncodified law. What kind of a law it is? Uncodified law. Sir, what does uncodified means? Means they do not have no sections. Just like law of crimes has sections, everything else has sections, but the law of tort is a pure concept from UK origin. From which origin? UK based. Okay, and Indian point of view, you don't have any particular sections of it. Nobody can tell you section number, this is law of tort or anything. Okay, the person who does a crime is called as a criminal, whereas a person who does a tort is called as a tortfeasor. Is called as what? A person committing a tort is called as a tortfeasor. Clear? Okay, and tort is a civil wrong, and for that civil wrong what do you get? Compensation, because in crimes only you can get imprisonment, but in here you only get compensation, and it should not be exclusively breach of contract. If it is a breach of contract, will the rules of tort apply or the rules of contract act will apply? If it is a pure breach of contract, will we follow law of contract or law of tort or law of contract? Obviously it is a codified law. So if it is a breach of contract purely, then you will go as per section 73 to 76 of Indian Contract Act. So for this, all other things will come here, civil wrong. Okay, like trespass, or you could say defamation also can come here. Defamation can come in criminal as well as civil laws. It is on the person whether he wants to go to the court and file a civil case or criminal case. If he wants a person to go in jail, he will file a criminal case. If he wants to get money out of that person, then he will file a civil case. Very good. Okay. And crimes are treated as public wrongs. So what if it is a public wrong? Who will file the case? Government. So complainant is always government, or complainant will be police station of so and so or state of Maharashtra or like that. However, if it is a tort, if someone is sitting in my garden, will court come and give me remedy, or I have to only file a case? So it is a private wrong. So that person only has to do. If someone is talking bad about me, will the government take action or I have to take action? Because it is a private wrong. Very, very simple. In here we get compensation, tort, whereas in here the person will get imprisoned. Now we come to the essential ingredients of tort. Ingredients of torts means what? For a tort to happen, for a civil wrong to happen, three things are needed. Wrongful act, obviously something wrong must have happened. So for a civil wrong, three things are there. One is a wrongful act. Second, legal damage should be there, and then if there is a legal damage, there will also be a legal remedy. So in torts, there are three important aspects: wrong, which causes damage, and for which you will get remedy. Logical, complete. Now, from the concept of legal damage, there are two maxims: damnum sine injuria and injuria sine damnum. Market is important. Okay, two maxims that we have to know. Now pay attention to this. Once you get the words correctly, this becomes a cakewalk. Damage means loss. So damage means loss. Sine always means without. And injuria means legal injury. Concept clear? It means legal injury. So a loss without legal injury sounds so weird. Now you tell me, if there is a loss to you but without a legal injury means what? In eyes of law. So there is a loss to you, but in eyes of law there is no legal injury. Example is Rochester Grammar School's case, which we can say competition. Okay, competition. So what happened? There was a school. From that, all the teachers, they started a competing school. So that caused loss to me. But in the eyes of law, there is nothing wrong happened. So will I get remedy? So if it is without legal injury, if in the eyes of law there is no legal injury, then it is called as it is not actionable in court. It is not actionable in court. So will I get remedy? If you cannot take action in court, then will you get remedy? No remedy. Means it is allowed. So competition, legal competition is all perfectly allowed. So someone opens, your employee goes and starts a competing business. Cannot do anything. Clear? And you have to remember the case, Gloucester Grammar School case. Now if I go into the next one is injuria sine damnum. Always injuria means what? Always injuria we saw here. What does it mean? Legal injury. And what does legal injury mean? In eyes of law, the injury should be there. Without damage. And damage means loss. So for example, in eyes of law, there is damage, but to you, there is no real loss. Now, example of this is Ashby versus White. Now, in Ashby versus White, what happened? They did not allow her to vote, but her party only won. So, did she get a real loss? She won the case. So, they said that if he's won, what problem anybody has? So, if that person has won, there is absolutely no problem. But in the eyes of law, refusing a person to vote is a violation of their right. So if it is violation of their right, is it actionable in court? It is actionable. If it is actionable, will they be given remedy? Yes. Clear till here? So not allowing a person to vote, even if they win the case, still action can be taken in court. Perfect, done. Then we come to three important types of liability. If in the exam it comes, it will be from these three liabilities only, which you need to know. Okay, which is called as strict liability. I'll tell you. Okay, now let's see which are the types of liability covered. Most of the students do get confused in this. Okay, let's see. There are liabilities given. How many types of liabilities are there? Three. One, the first one is called as strict liability. The other one, yeah, absolute or vicarious liability is also there. vicarious strict, let's say absolute liability. Okay, and the third one is vicarious liability. Okay, let me explain all in one go to you. Okay, then you can look. So strict liability simply means that if any person gets any dangerous substance or animal, if any person brings any dangerous substance or animal, and if it escapes, he will be liable, yes or no? He will be liable. He will be liable. Simple little point. So if any person gets any dangerous substance or animal and that thing escapes and causes loss to another, I will be liable, I have to pay for it. This was laid down in which case? Ryland versus Fletcher. Clear? Absolute liability. Now in this, exceptions were given. Certain exceptions were given. Act of God, beyond the control, some third party intervention. So in absolute liability was founded in MC Mehta versus Union of India. They said that same copy pasting as a strict liability rule only, but without exception. So it is called as no exception rule. What it is called? No exception rule. So same Ryland strict liability, but only the exceptions are removed. And now when I say vicarious liability, means being liable for fault of another, being liable for fault of another. Clear? Being liable for the fault of another. Example: if the servant does a mistake, who will be caught? Master. Then if I go to see if child does, parent will be held liable. If the contractor does, who will be held liable? Principal. Or another word, if I say agent does wrong, who will be held liable? Principal. If one partner does a mistake, who can be held liable? Other partners can also be liable. Concept clear? Yes. Now let's see and complete it. Okay. First we come to strict liability. So strict liability is a different rule and absolute liability is different. Strict is with exceptions and without exceptions is absolute. Rule of Ryland versus Fletcher. What was the rule laid down? That if any person brings any dangerous animal or substance and it escapes, then he brings it at his own peril. What do they say? He will be responsible for it. Finish. Okay. So this guy built a reservoir. It went and destroyed the other person's property. He was held liable even if he had kept an independent contractor. They said, listen, you made a reservoir, you built it, you brought this independent contractor, so you will be liable. So who was liable to pay compensation? Ryland. So Ryland built a reservoir and destroyed Fletcher's property. Ryland was held liable. Simple. What is the rule in Reed versus Lion? You can write this in Reed versus Lion. 4 ingredients are there. What is the keyword? Bend. Always remember what is the keyword? BEND. Okay. So whoever brings any dangerous substance and it escapes, you will be held liable, and it should be non-natural use of land. Only one extra point that you have to remember is non-natural use of land. In simple words, this means unusual. When you do something unusual. For example, if I get a cat and that cat injures someone, will I be held liable? No. Because that is a common thing which people are normally keeping. A dog I get and it escapes, causes damage, will it be held liable? No. Again, dog is something which everyone does. But in Dubai, you go to see lions are kept, tigers are kept, and then you leave it. Will you be held liable? Yes. because it is something unusual. So similarly, setting up a reservoir is unusual, reservoir. But having a water tank, is it unusual? No. So there was a case where the water tank burst. Will it come under this rule? Answer is no, because every building has a water tank. Clear? Reservoir everybody doesn't have. So remember the keyword bent. You must have brought it, it must have escaped, it must be dangerous, and one extra point, that is non-natural use of land. Now I told you that in absolute liability there is only one difference. What is the difference? No exceptions. This has exceptions. Okay, this has exceptions. Now what are these exceptions? Let's understand. First, in this, these are, I could call it as defenses. Okay, where he will say I will not be liable here. So how Ryland was held liable? So if you fall under these defenses, you will not be liable. For example, I say it is natural use of land, or I say that guy consented it, or I say it is act of some third party has come in, or if I say that government has told me, statutory powers I have, like a government building a reservoir will be statutory powers, they cannot be held liable. Act of God and plaintiff's own fault. So how many exceptions have been given? 6 exceptions. So if these 6 exceptions are there, it is an exception to the rule of strict liability, means the person will not be held liable. Now we come to absolute liability. It is the same rule, but in India, the case, if you see the name only, Ryland versus Fletcher, are they Indians? Are they Indians? No. But you see this case, MC Mehta versus Union of India, Indian case or no? So what happened is, the Justice Grover, see his name will also be there somewhere. Okay, so it was Justice Grover who said that, listen, we do not have to follow the UK laws exactly. We can make some changes in them. So we will form our own rule called as absolute liability. That whenever, and this happened due to two things. One, there was a Bhopal gas tragedy, and exactly after 1 year there was an oleum gas leak. And every time the manufacturers of the factory, what they used to say, act of God, act of God. They said, listen, we, for hazardous industries, we will have to say that if there is you're getting a dangerous substance and it is escaping, you will be absolutely liable without exceptions. This is the rule. So today, if there is any industry, they can never claim any defense. Zero defenses. Okay. Now coming to vicarious liability. Now vicarious liability means what? The tortfeasor, the person who does the wrong, normally they are, the person who did the act is normally punished, but here you will see someone else is being liable. If the agent does wrong, principal will be held liable. That's vicarious liability. They are vicariously liable for their masters. Partners, one partner does wrong, all the partners can be held liable. Servant does anything wrong, the master can be held liable. Okay, because these are some two maxims that let the respondent superior, let the principal be held liable, and concept facet. You know, what does it say? That one who does the act through another does it himself. If I am doing it through someone else, it means it is my own act. Employer and independent contractor. So if you are appointing an independent contractor for dangerous substance, the person who has appointed will only be held liable. Always. As we saw in the case. Okay. Now we see some wrongs with respect to personal wrongs, like to a person, the human being. Battery. Battery means what? There is use of force without lawful justification. So someone has punched someone, it is use of force without lawful justification. Assault is one step lower. What does it say? It is apprehension that battery will be committed without lawful justification. So in battery there is physical contact, but in assault it is a apprehension, a anticipation, a expectation, a feeling in the mind that he is going to commit battery against him. Okay, simple little points. Then when we come to bodily harm, now what is bodily harm? A willful act calculated to cause physical harm to the plaintiff. In fact, causing physical harm to the plaintiff is a tort. Bodily harm means what? A statement that cause physical harm. Now, how can a statement always cause physical harm? So, a willful statement that causes physical harm. Statement. So, for example, there is a blind person. He asked me, should I go ahead? And I know that there is an entire well or the road ends. Still, I tell him, yeah, go ahead. So, what happens? He gets hurt by my statement. Another thing is there. Again, a blind, everything is on the surrounding a blind man only. Let's say a child is there, some innocent person is there, or some person comes, he tells me, can I have this liquid? Let's say I had kept a detergent on the table, and he comes and he says, Are, how are you? I say, I'm very nice. He says, Are, which juice you're having? I said, it is Tang. Very good juice it is there, you have. He has and he falls sick and gets injured. Okay, gets food poisoning. So he can file for bodily harm because my statement, I did not physically contact him. Okay, so it will be covered. Then comes false imprisonment. False imprisonment is very simple. Just remember imprisonment, what happens? Can you move around? There is a total restraint on your liberty. So when there is a total restraint without lawful justification on your liberty to move. So there was a case where a teacher said to the child, he locked the child in the classroom and went home. And next day she came because that person did not do the homework. Now I had also given you all homework. Imagine if someone goes and locks the door and next day they come and so they can file a case of false imprisonment that I have been totally restrained all directions, all four directions, and without lawful justification. Clear? Then comes malicious prosecution. Now malicious prosecution only sounds difficult. Okay, that means a fake case. Malicious means what? Fake. So if someone has filed a fake case on a person, can I say, let's take, I don't know whether you all will be knowing this. Sushant Singh Rajput was there. Okay, and you had Riya, his girlfriend, who was accused for committing the particular death, caused the death or aggravated the death of Sushant. Now what happened is, CBI later reported that she was not involved and gave her a clean chit. But can you say by that time she had already lost reputation in the market? So if she wants, okay, so if a person says that he has been wrongly accused or wrong case was filed against them, which has caused them loss of earnings, loss of job. So many times we see someone has filed a fake case. There was a case where, in Delhi, if you read Delhi Ka Darinda, where one lady, she accused a person that this person is harassing me, which went viral on news channel, and he was removed from his job. He was lost everything, and later in the court he won the case that he had not done anything wrong, but by that time he already lost everything. So when a fake case was filed against you, now that innocent person will file a case for damages to recover the compensation. So when a person files a fake case against an innocent person, the innocent person suffers damages, yes or no? Then that innocent person can file a case under for damages. Okay, so a fake case was there and it was without reasonable cause and it terminated in favor of that person. Okay, so then in such cases that person can claim damages under torts. So a prosecution was there without lawful justification, it was acted maliciously, the person suffers damages and it terminated in favor of that innocent person. Then that innocent person has a right to file for damages under malicious prosecution. That a fake case was filed against me because of which I lost so much money, I am asking for compensation. Now we are talking of nervous shock. If imagine a person comes ahead and says that the exams have been preponed. Okay, and the uh, 80-page amendment sheet has been introduced. Tell me, how will the student feel? Okay, so obviously already they are scared, or I can say already they are very scared, and on top of that, someone is playing a prank. And let's say weak-hearted people might have fallen ill for 3-4 days, because of which they couldn't study, and company law portion was pending. So in that case, they can file a case, okay, of nervous shock that may be cause them physical injury, because sometimes a person can get a heart attack. Okay, so your nervous shock is not that you hit someone with a stick, bullet, or anything. It is the uh, words that give a person tremendous amount of shock, or you could say emotional disturbance. Then comes defamation. Defamation we've already done. Defamation is an false statement with the objective of reducing a person's reputation. It could be libel or slander. Libel is always in permanent form, and this is in transient form. Transient means temporary form. So actual cartoon images etc. is libel, and slander is what? Words etc. Then we comes remedies under tort. This also once they have asked remedies. If something wrong has happened, what you will do? Where will you go? Court. So in court, what you can ask? Damages. You can ask the person to stop doing that act. And third is ask for return of the property. That is called as restitution, means restoration of property. What does this mean? To restore the property. So if someone has taken my car wrongfully, I will ask for to restoration of property. Okay, simple. Now, always you don't need to go to court. Law also allows you some extrajudicial remedies where you can take the, you can take the particular remedy yourself. Okay. So let's see. First is self-defense. You yourself defend and it's fine. Second is you prevent. If someone is doing trespass on your property, entering on your property, you yourself can prevent it. Third is re-entry on land. So if someone has entered in your land, you go and re-enter. Recaption of the goods. Recaption means recapture of your goods. So if I have sold the goods and he's not paying me the money, I can go and take my goods back. Okay, simple. Abatement of nuisance. If any nuisance, someone is there playing loud music, will you go to the court to complain or remove the plug? Remove the plug. So that is there. You will lawfully take action to remove the nuisance. And distress damage feasant means what? It's a very complicated sounding word. It's very easy. It is related to cattle. If any cattle has entered in your farm and has eaten all your crops, now what you will do? You remove the cattle, but what about the loss? So you will seize the cattle, that is, you will keep the cattle till the money is returned, or you make the cattle do the work. So whatever till you recover the money. So that kind of law detention is allowed. You seize the cattle only till your money is repaid. Finish. Okay. Then comes one very important things which might not be taught in your first level, but it comes in the second level. Vicarious liability of the state. Very important. Okay. So can the state be held liable for the wrong of their servants, employees? Answer is yes. If the government driver has caused an accident, the state government will pay compensation. So there was a case of state of Rajasthan versus Vidyavati, state of Rajasthan versus Vidyavati, and also in case of P&O Steam Navigation Secretary of State, which state that the state can be held liable for the wrong and damages done by their servants. Okay. Even here, in Kasturi Lal versus state of UP, the government was held not liable for the tort committed by its servant because it was committed by him in the course of discharge of his statutory duties. The court held that the government was not liable as the activity was involved in sovereign activity. Now, very important. Here they are not liable. They was involved in sovereign activity. Now, let me tell you the full rule. Now, if you've not written it, write it down. Can government be held liable under torts? So the answer is it depends whether it is a sovereign function or whether it is a non-sovereign function. Clear? Now, if it is a sovereign function, means the government is acting as the supreme person, okay, sole body, then they are not liable. State cannot be not. But if it is a non-sovereign function, then the state will be held liable. Simple little points. So let's take an example. A defense of India is the sole responsibility of government. Self-defense is different. I'm talking of someone crossing the border and coming inside. Can you go and fight? Answer is no. It is the army, the government is there, they will be going there. Okay, so that's a sovereign function. But if government could not fulfill that and there is an attack, can you hold the government liable? No. That you cannot tell the government that someone has come and damaged, now you pay me compensation, because they were acting in sovereign capacity, in supreme authority. Okay, let's take another example. If judiciary, courts, tell me one thing, that can you form your own court? No. Courts are there, High Court, Supreme Court, they are also supreme, they are coming under the government. If, for example, a wrong judgment was passed by the judge and in superior court, okay, it went and was reversed, can they file a case on the judge? Answer is no, because they were acting in sovereign authority in good faith. But every other thing which private sector is also giving, so wherever the private sector, government is competing with the private sector, for example, your post, there is a private couriers and there is government couriers. So government is competing with the private players, there they can be held liable. Let's say government is giving transport, and let's say there is even other public transport of Ola, Uber. So if there is a damage where the private sector is being held liable, government can also be held liable. But wherever the government is acting for the benefit of the country and nobody else can do it except the government, like printing currency, ensuring, another thing, RBI functions. Only RBI can do, na? You can't do. Money circulation. If I see that inflation is too high, can you ask for compensation? No, because they are acting in sovereign function. So just remember all these case laws, and you have to write, it matters whether it is sovereign function or not. If government has sovereign functions, then they can claim immunity. They can claim defense. Clear? So there was a case, okay, a innocent person, Rudal Shah versus State of Bihar. Petitioner was detained illegally in prison for only 14 years. So 14 years he was in jail, and later they found, so then they gave him compensation for 14 years, rupees 30,000. Okay, but they cannot demand, government voluntarily gave. With this, we've completed the entire chapter, including all the past exam questions. Thank you. Clear? Everyone clear till here? Yes or no? Yes or no? Yes. Okay. So today we'll be doing this much. You want to do any other? Okay. So today we'll be doing only this much, and the balance part, obviously the other chapters are also there. I will be coming closer to exams also with some marathon, but at least till here you can complete all your chapters, and I will be launching something very, very big for all of you all. That is your dream batch and test series. The announcement will come in a few days. So to get that announcement and get the links for enrollment of that, you have to join the WhatsApp group, stay there, and also share it with your friends. can help a lot. So it's my only request, share this video with your friends as well. I will see you in the next lectures. Take care guys, bye.